What's up, everybody? Welcome back into an episode of The Lawyer You Know. And like we said, so much going on in Massachusetts as Brian Walsh's trial started kind of this week, but it started with a bang as Brian Walsh pled guilty to 2 of the 3 counts that he's charged with. And I heard so many people thinking, ooh, is that evil genius by his criminal defense attorney? Are they going to cut out all of the bad evidence against him now? All of the search terms that make him look so guilty? Has this trial completely changed? Was this a genius move? How often does this happen? And what will the trial look like now? Why would a defense attorney do this? And how would a prosecutor respond to it and use it or react? We're going to get all of those answers today in this episode. I'm going to bring my dad on and we're going to talk about it from both sides, why you would do this as a defense attorney, what possibly could be happening and why they're making these decisions. And if we were prosecuting this case, how we would deal with a last-minute plea of guilty by the defense attorneys. Let's get to it. Everybody hit that like button. Make sure you are subscribed because we are going to be following this trial if it happens. All right, so I know so many people have so many questions about this entire situation of what happened with this last-minute plea deal. We are going to watch part of that plea together and break it down and talk about the different parts of it. We're going to skip the beginning where they do the plea colloquy, and she asks him, like, you know, how long did you go in school? Can you understand reading and writing? You're not under the influence of anything today. But I want to ask you, Dad, first. We talked last, which was Monday's podcast. It seems like it was forever ago, about competency. Do you think if the lawyers knew that a competency issue could possibly pop up and they knew a potential plea like this was coming up, would this be something a criminal defense attorney would do to make sure everybody's on the same page, that we have confirmed, Judge, he is competent, the medical professionals agreed, you agreed, we agreed, and now we're going to take this plea deal? Because a big part of the colloquy is it a knowing and intelligent waiver of his rights in order to make a plea deal?
Well, first off, let's really define it. It's not a plea deal.
True.
They are pleading open. There's no guarantees, no deals from the state. They're just walking in and saying, we're guilty of these 2 counts. So that's number one. Number two, you always want to CYA that your client is competent so that you do not have this coming back to bite you later. So I don't think it was the reason for the competency, but I do think that they were happy they had the competency since they were making this strategic decision, because it's not a decision that's common. It happens. People might think it doesn't happen. This does happen, where you will plead guilty to one of the counts because you know that count is going to come up later, and we'll talk about that. So you plead guilty to it to make sure that it's a clear understanding about what you're pleading guilty to, but then you don't plead guilty, in this case, to the M. And therefore, you make it, it's a strategic decision, and, you know, we'll get into it.
So let's wait. I don't want to talk about what the strategy is behind the decision yet, because we're going to get into that. We're going to talk about what the strategy is from the defense side and how you deal with it from the prosecutor side. But you also answered the next question, which, how unusual is this? You said it does happen, but it's not common. It's not common to wait to the last second to make a plea here and to plea open to the court to only some of the charges while some are still going to trial. It is definitely unusual, but it does happen from time to time.
Right. Because again, you got to realize that means you're not walking out of the courtroom. Of course, he's not anyway, because he's been sentenced on another case and he's serving time. But, you know you're not walking out of the courtroom because you pled guilty to some of the charges.
And it has happened in some high-profile cases in the past, including some cases in Boston that we'll talk about why the attorneys did it in that case versus why they might be doing it in this one. Okay, let's take a listen to the plea, and we'll stop it and kind of talk through it and answer your questions and talk about strategy as we're listening to it.
Trial in this case. And I'm going to ask, sir, that you listen carefully, because when the ADA is finished, I'm going to ask you some questions about the facts that the ADA has stated.
So we've kind of skipped the part where he said, yes, I want to change my plea. I'm going to plead guilty to 2 of the 3 counts. And now we're getting to the factual basis. And I wanted to play the factual basis specifically here first, before we get into the strategy of why would defense attorneys do this and how would a prosecutor react.
And I want to tell too your listeners, listen for the M word when they're talking, when the prosecutor is talking now.
Thank you, Your Honor. Your Honor, regarding count 002, misleading police in violation of Mass General Laws, Chapter 268, Section 13B, on or about or in between January 1st to January 8th, 2023, Mr. Walsh did willfully mislead police officers with the intent to impede, obstruct, delay, prevent, and otherwise interfere with the criminal investigation to the disappearance and murder of Anna Walsh. The defendant first misled.
So that was the M word that you were talking about. I'll slow it down all the way just because it's not super clear. So that was the M word you're talking about. And
Yes.
they're basically setting up, in order to take a plea, there has to be a factual basis. You as the defendant have to agree with that factual basis in order to understand, and the judge say, okay, you know what you're pleading to. They talk about the maximum penalties here and that you know you can't have a trial and things like that. So you have to do that under the rules. And this factual basis, in my opinion, could become really important later.
Right. And the prosecutor, by the way, slipped in the M word. That is not in the charging document. He slipped that M word in order to try to, help his case.
And the defense attorneys catch it. They're good defense attorneys.
Right.
They're really
Oh,
paying
they're very
attention.
good. Yes.
Misled the Cohasset police in the morning of January 4th, 2023, when after he reported his wife, Anna Walsh, missing. He stated to a Cohasset police officer that Anna Walsh had left the Walsh residence at 516 Chief Justice Cushing Highway in Cohasset on the morning of January 1st, 2023, by taking an Uber or Lyft to Logan Airport when returning to Washington, D.C. for a work emergency. The defendant then continued to mislead police officers. When he made additional false statements about Anna Walsh being alive and voluntarily leaving the Walsh residence.
And the loud noise in the background is the judge shuffling papers because her mic is pointed down. So it's the best we can do. But he's explaining the factual basis of him misleading the police right now. People are asking if he's a public defender. I've heard he is. I've heard he's not. I've heard he's court appointed, a private court appointed attorney. Doesn't really matter. He's doing a really good job. And so is the female attorney on Walsh's case.
As well as when he detailed his whereabouts on January 1st, 2023, to Cohasset police and Massachusetts State police officers. The defendant continued to make false statements when the police officers from these agencies met with him, including on the evening of January 4th, on January 5th, January 7th, and January 8th. In January of 2023, the Cohasset Police Department had approximately 20 full-time police officers, including 2 detectives. The Cohasset Police devoted all available resources in an attempt to find Anna Walsh. They requested assistance from other departments and agencies. And on January 6th, the Cohasset Police Department conducted a press conference seeking help in locating Anna Walsh. As a result of the defendant's false and misleading statements, law enforcement agencies and police officers took many actions, which had a heavy financial and emotional cost. These included the Cohasset Fire Department searching a swimming pool at the Walsh residence, teams of police officers from multiple agencies and departments, including a K-9 teams participating in large-scale canvass of the area around the Walsh residence during inclement weather. DC Metro Police attempted to locate Anna Walsh in Washington, D.C., and Massachusetts police officers, including Cohasset Police, Massachusetts State Police detectives, and other units from Massachusetts State Police, traveled to Washington to search for Anna Walsh in a result of the defendant's false statements. The defendant's conduct was willful. His statements impeded, obstructed, delayed, and otherwise interfered with the criminal investigation, and the delays resulted in contents of dumpsters in which the defendant had disposed of Anna Walsh's remains being incinerated.
Why don't you pause there? We'll deal with count 1 and count 2, and then we'll go to count 3.
Yes, Your Honor.
All right. So, Mr. Walsh, did you hear what the assistant district attorney just said with regard to the statement of the offense conduct for indictment 002, misleading police?
Your Honor, if I may, Mr. Walsh is prepared to admit to the recitation of facts with respect to the indictment that the government just read, insofar as it alleges he did impede and obstruct the criminal investigation into the disappearance of Anna Walsh. We obviously object, and he's not admitting to and murder. The second portion of the facts that the government just read that we would take issue with is the last sentence, and the delays resulted in the contents of the dumpsters into which the defendant had deposited Anna Walsh remains being incinerated. Insofar as the rest of the facts, he's prepared to admit.
All right. Mr. Walsh, you just heard what Attorney Porges said, sort of the insofar as. It's another way of saying it limited to this. And you heard what your counsel just said. Understanding those limitations as just articulated by your counsel, did you do or join others in doing those acts?
Yes.
Do you understand that by pleading guilty that you're admitting to the facts described as revised by your counsel are true?
Yes.
Are they?
Yes.
Mr. Walsh, did you in fact willfully mislead various law enforcement to include members of the class?
So I'm going to pause it real quick for a second here because I want everybody to understand these questions the judge is asking him are very important. I'm going to play out the rest of this and then we're going to stop and discuss a little bit before we get to count 2, which is the, moving a body or dismembering a body or whatever. But the lawyer did a good job to point that out, like my dad mentioned earlier about them kind of adding words to the indictment.
Mislead various law enforcement to include members of the Cohasset Police Department and the Massachusetts State Police with the intent to impede or interfere with a criminal investigation of Anna Walsh's disappearance.
Yes, Your Honor.
All right. Moving to indictment number 3.
Okay. So we hear that back and forth. We hear him say, yes, I did. She asked him specific questions and we heard the factual basis. So we know that there's more coming, but what is the thought process behind this as a defense attorney? A lot of people are asking, how does this help him? We'll talk a little bit later about what evidence can be excluded, but what reasons do defense attorneys do this at the last minute, plead to 2 of the crimes and leave the most serious crime on the table?
Oh, do you want to talk about it now, or do you want to, because these comments apply to both counts 2 and 3. And I don't know if you want to go through count 3 first before we do it.
No, go ahead, because I want to
Okay.
highlight what the strategy is so that they've seen count 2 and then they'll know what the strategy is when they hear count 3 after our discussion. I think they'll view it differently after our discussion. So let's go ahead. We can have the
All right.
whole conversation right now.
All right. Obviously, we're speculating. And so we're guessing because there are several options that could be going through the mind of the defense lawyers. One is an attempt to limit the evidence. They could try to say, well, Judge, we pled guilty to it now. It's not relevant to bring this up during trial that he lied to law enforcement. Now, I can tell you that most judges are going to go ahead and let the facts that he lied to law enforcement come into evidence in the M case because it shows a consciousness of guilt where you're lying about where your wife is, where you're lying about an Uber, where you're lying about, she's in DC or you don't know where she is or she's still alive. All those lies show you trying to cover up the M. And by trying to cover up the M, it's evidence of the M. Now,
So
go ahead.
Well, hold on. So, because you've kind of like answered the next question, but I really want to focus first on just from the defense's point of
Right.
view. What are you trying to do when you plead guilty to this? So you're trying to limit the evidence that is relevant to the M charge. Okay. That's one theory in your mind. I'm
That's
trying to
one.
limit the evidence they can use against him.
Okay.
Another one is,
Okay.
Go ahead.
Well, my second one would be that you're preparing for him to testify. And
Okay.
that if he's going to testify, then this way he's going to have to admit these things anyway during his testimony. Therefore, you're not showing that you're hiding something or that it's not something you're going to bring up. So you're going to bring this up anyway. So you're going to bring it up anyway. Your client's going to admit it. So why not go ahead and plead to it so that you take that issue off the table for the jury and the jury doesn't have to make a decision. But I think there's a good chance that he's going to testify, which is, I think, one of the real reasons why they're doing this.
So another one is you're setting up kind of what your theory of the case is going to be as a defense attorney. So if he is going to admit to these 2 counts and he's going to plead guilty, then that allows you to try and figure out how can he be guilty of these 2 things, but not guilty of the M, right? And so there's only a couple ways that happens. And one is an accidental death, or he wakes up in the morning and he doesn't know what happened. In some of the other cases in Massachusetts, that's exactly what happened. And it's been successful in the past that, I didn't know what the heck happened to her and I freaked out, which is why dealing with some of the evidence that still may come in, it all makes sense. I freaked out. I started Googling things And that all makes sense because it was an accidental death when I woke up. So they're starting to set up what their theory of the case may be throughout the trial.
But in order to do that, he has to testify. Because where's the evidence going to come in that it was an accidental death, or it was,
Absolutely.
or self-defense? No, she came at me with a knife. All that has to come in only, and it can only come in with him testifying. So that's why I think this could be a preparation for him testifying.
Another reason that I've seen it happen in the past, and something that comes from it, is they're trying to continue plea negotiations. And by taking responsibility for some of it, and maybe they put this theory forward, and throughout the trial, maybe it's going well for them that this was accidental, or he freaked out and pushed her when she came at him. And so maybe it's second degree, or maybe it's manslaughter or involuntary manslaughter, or like you said, self-defense, in that maybe that'll open up communications with the prosecutor and the defense attorneys to maybe he'll plead to second degree. Maybe he'll plead to manslaughter. Maybe he'll plead to something that gives him the possibility of parole, which first degree does not. And first degree carries with it the automatic appellate issues that's going to drag this case out longer. So will the prosecutor take some kind of guaranteed life sentence with the possibility of parole on a second degree M charge while they're starting to take responsibility and keep the door open for that? It can also be a stepping stone in a plea negotiation.
It can be. Thus far, from, again, what I've read, the Commonwealth has told them, no on any plea negotiations, no on any deals. And so they've been very firm on not making a deal. So the only thing that'll change their mind is if the trial's going bad for them. And so during the course of the trial, again, we've always said this, trials are living, breathing things. And during the course of the trial, things could change. The facts may look different, and the prosecutors may think that they need to make a deal. But right now, they're steadfast, no deals.
Right. And that makes sense. And to me, this is a huge indication as to just how strong the case is against Brian Walshe, in my opinion. Because I think one of the reasons they, quote unquote, get out ahead of this and do this and make this, quote unquote, again, strategic decision is they're cooked, and they know they're cooked on these charges. There's so much evidence that he lied to police. There's so much evidence he misled police. There's so much evidence what he did with the body. So all of that, from my perspective, they were going to get cooked on anyways. So if you fight something and the jury you lose credibility with the jury to say, I didn't lie to police, I didn't do anything with their body, and it's so obvious that's not true, you've lost credibility with the other arguments as well. So if you can try to gain some credibility, which seems like an oxymoron, that I'm going to gain credibility by saying I lied to the police, but I'm telling you the truth now about lying then, but I'm not lying to you. Like, that's not great, but you don't have a lot of options. I think that's one of the things they're trying to do as well, is to build credibility instead of lose it on charges they know they're going to lose on.
And they're also giving up an argument. They're giving up the argument that she's not dead.
That no body, no crime, right? Because that's a good one.
There's
the
no
no body,
body.
no crime, right, is a really great argument in a lot of cases. It's successful in a lot of cases, but now we know there's no body because of Brian Walshe. We don't know that she's dead because Brian Walshe, but we know there's no body for anybody to have ever tested and confirmed whether this was accidental or whatever because of Brian Walshe.
Right. It worked great in the Casey Anthony case.
Right.
They never found a body. And I think that was a real key in her being acquitted. So they've given that up in this case by doing these pleas. Right.
So is there any other strategic advantage or something that you can think of from the defense? Another thing that I know we said they're going to try to block some evidence, but maybe there's a thought that the misleading police and what happened with the body all happened after the crime. So they're going to argue to the judge that all this evidence after after she died, is irrelevant. We'll talk about whether or not they're going to be successful in those arguments, but anything else that we haven't mentioned that you think could be a strategy decision on the defense's part?
Well, it could be that, again, they're setting up for his testimony. And
We've mentioned that already. I'm saying anything we haven't mentioned.
Well, I'm going to lead to opening statement, in that they may be setting up an opening statement where they're going to get ahead of all this. They're going to tell them he's going to testify and tell them that she came after him with a knife. So if they're going to give an opening statement like that, then they might as well plead guilty to these counts.
Right. Okay. Yeah, it's a good point. Again, setting up their strategy and how they're going to try the case. So there's kind of two answers I want to give. I don't know how they'll mix in, but okay. So here's what we're going to answer here and kind of talk about. Hello, lawyer, Peter, why did the Commonwealth agree to this? So that's the first question that I want to talk about. first off, the Commonwealth doesn't have to agree. I called it a plea agreement. It was not a plea agreement. It was a plea open to the court. And if the Commonwealth is going to charge me with something and I want to say I did it, the Commonwealth can't stop me from saying I did it. The judge is going to sentence him later on to whatever she feels appropriate. And she even tells him in the plea colloquy that we didn't play all of it, but that she's not married to anything. She's not bound by anything. She can choose the sentence that she believes is fair within the rules, obviously.
Right.
Okay. So we're going to talk about what the prosecutors are going to do, but also in the vein of, could he be doing this so they can't get those horrible Google searches in? Okay. So now let's talk about what evidence, and I'm going to mention some evidence. You've already mentioned some that is really, really bad for Brian Walshe, that I heard a lot of people saying, oh, now that evidence is not coming in. The defense is a masterful job. They've just kept out all this damning evidence from Brian Walshe. Now they could win the trial. So we're talking about Google searches about, how to dispose of a body. Can you put a body in a dump? How do you get rid of a body? Can you be charged with a crime if there's no body? Text messages to people, searches on the iPad, just so many bad things, right? That have to do with the body, that have to do with lying to the police. Comments he made to the police. Comments his lawyer made to the police where he was telling them lies that were obvious lies about where his wife is and was. Okay. So all of that evidence has to do with these two crimes he's just pled guilty to. Did they, as the defense, effectively block that evidence from coming in now?
I don't think so. I think you'll hear the objection exactly as you phrased it, but it's coming in. Those Google search, I mean, those are killers. I mean, those Google searches. I think one is, how long does it take a body to smell or something or decompose? I think there was a Google search like
Horrible.
that. Yeah, I mean, there's a horrible Google, which comes in later when we talk about cross-examination if he should testify. But all those Google searches are just going to be killers. For how he's going to explain those Google searches, I just don't know. I can't wait. And that's why I think that the opening statement, if they're going to put him on the stand, I think they're well advised to give an opening statement that's going to show all of their excuses for all of this evidence before it comes in. It gives them that opportunity to put that in the juror's mind, because any logical juror is going to think, what possible explanation can there be for these Google searches?
Yeah. And I think if I'm the prosecutor, I have amazing arguments as to why all of this evidence still comes in. The fact that he pled guilty to it doesn't change one bit of evidence that I'm planning on submitting to this jury, because the whole point of lying to the police and getting rid of the body is not just consciousness of guilt, but it's also covering up a crime you committed. And what you do after the fact can absolutely be evidence of what you've done in the past, the modus operandi. It could also be, we don't know their theory of how he ended her life, right? The prosecutors have a theory that Brian Walshe ended Anna Walsh's life, right? Maybe it was by chopping her up or, taking her all around town or whatever. That could be a theory of how she actually died, not just getting rid of the body. So that evidence is completely relevant, right? And the testing that they did at the house and what they found at the dump and et cetera, from my perspective, it doesn't change any of the evidence coming in, except maybe around the edges, some of the things that, technically you did move it from one place to the other or whatever that you had to specifically get for moving the body or for misleading police.
Right.
But all of that goes to proving the elements and the facts that are essential to the M charge, in my opinion. And for a judge to exclude that just because he pled guilty would be so anti-justice, it would make no sense.
Right. Well, when the prosecution gave the factual basis for the plea, they said things in there that aren't going to come in evidence. It is true. They talked about how many man hours were put into this and how much what the investigation was like and all those things. They're not going to come in. But the specific facts of things that actually happened and why they happened, that's going to come in.
So let's talk about.
It becomes a different case, but these pleas make it a little bit of a different case because now they're admitting that there is a body and that she is dead. So that changes the case to how did it happen as opposed to did it happen. So it does change the way the prosecution is really looking at the case.
Yeah, your strategy changes because a big part of their case was probably proving that she actually is dead, right? Because theoretically she could still be alive. Right. And, he said stuff like, yes, I'm married. And they had to go back and say, well, no, You can't come in, or you can't say that you're married anymore legally. Somebody said, but Melanie Little said, based on MSL, that won't come in because it's prejudicial. AI think that's what she said. And that's fine. She may have said that, and lawyers can disagree on this, and we'll see how it all plays out. And maybe we're wrong. Maybe the judge is going to say, oh yeah, that's too prejudicial. It's like, yeah, those Google searches are prejudicial. I agree with you, but they're proving facts that we need to prove in this case. Number one. Number two, we already did motions in limine. I didn't end up doing a video on it, but I watched it. And the judge is letting Google searches in. She's letting text messages in. She's letting statements that Brian Walshe made to the police in. They already tried to cut all those out. They have not asked for another argument on the motions in limine. Nothing in this plea hearing was like, okay, judge, so now all this evidence is out. Make sure they don't say any of it in opening statement. None of that happened. I have seen no agreement. I've seen no additional argument. These were already all measures brought up on motions in limine. I do not see that there may be, like I said, some things around the edges, but the vast majority of this evidence, I still think is going to come in. And it sounds like you agree.
I do agree. And I think that when we talk about prejudicial, they're talking about the actual fact of a plea. The actual fact of the plea is prejudicial. That does
Sure.
not come in during the state's case in chief. It may come in later, and we can talk about how it would come in later. But
Yeah.
the state's case in chief, the state's case in chief cannot put in the guilty pleas. So that would be prejudicial. Those won't come in.
So here's a question. Can the state put in the questions the judge just asked and Brian Walsh's answers? Not, are you of sound mind and blah, blah, blah. But did you lie to police about what you knew about Anna Walshe? Did you do that? And he says yes.
The only way that that's going to come in, at least the way I view it, is if he testifies and if the defense opens the door to that type of cross-examination. In other words, if they ask a question and he lies or says something different than he said during his plea, or if he doesn't admit to things like he admitted in his plea, then they can bring in the fact, well, you said under oath this and you said under oath that. So that's why his testimony is so dangerous, is that all of these the plea information, not the fact of the plea, because that can come in under the normal impeachment, where if you've been convicted of a felony, how many times? They can ask that general question.
You don't say that you've pled to this. It's just 2 felonies. It doesn't specifically say what.
Right.
But
Right.
there's no doubt this could come in as impeachment if he says, no, I didn't do it. When
Right.
he's on the stand and cross, they can ask the same exact question the judge did. And if he said no, it's an under oath statement. It's perfect for impeachment or refreshing his recollection. My interesting thought, and what I would try to do, but this I could understand if the judge said is too prejudicial. I don't know why I wouldn't be able to bring it in during my case in chief and just read it to the jury as if it's a deposition of the defendant. It's a statement by a party opponent. It's a statement by a defendant. The evidentiary rules, I think, would allow the fact that Brian Walshe answered yes to those questions. I would try to bring that in. I would try to bring him answering these questions in. But I understand if the court would not allow that because it's prejudicial. But at the same time, it's like when you admit to committing a crime and you admit to that factual basis, it should be held against you. It should be prejudicial. Not to say, because you committed this crime, you obviously committed this, but just as a fact that, yes, you lied to police. Yes, you moved the body. Those things are facts that I think are proven almost by stipulation. It almost feels like it should be a stipulation you could read to the jury that Brian Walshe did, in fact, lie to police, and Brian Walshe did, in fact, move her body. Like, to me, those should be stipulated facts that they should read to the jury. And if I was the prosecutor, I'd work really hard in finding a way to get that in front of the jury because he has admitted those things, and I need those facts to prove my M charge. That's what I would really be trying to do. I would not give up on that just because he pled.
Well, I wouldn't either, but most judges probably would not let that in unless he testified.
And I get that. I get that.
And another thing too, the danger of his testimony is if he testifies, he's going to be up there forever, because how many Google searches are they going to ask him about? How many text messages are they going to ask him about? How many statements to law enforcement are they going to ask him about? He's just going to be up there forever, and he's going to get hammered and ripped to shreds. But again, I don't know how you present an alternative theory of the M unless he testifies.
Yeah. And again, some people are talking about the federal case. They were in the motions in limine. They were arguing, can this come in? Can this not come in? The fact that the ankle monitor is not how they, mapped his location, but instead it was with the phone. So they were saying it's not going to come in that he has the ankle monitor, but it may come in that he's out dealing with it on probation because that's part of his motive, because she's trying to take the kids away and using that federal charge against him, the cheating allegations and some comments she made to her friends. A lot of that is coming in. The motions in limine did not go well for the defense. The only thing that was kept out is what his lawyer said to law enforcement during that interview. But the judge is like, yeah, fine. You can't say what the lawyer said, but Brian Walshe almost repeated everything, and what he said is coming in. So the motions in limine were not good for Brian Walshe and his team. Almost all of the damning evidence is coming in against Brian Walshe. Everything we've been talking about in this case, where the majority of the world watching thinks he's guilty, it's not looking good for Brian Walshe. Tracy said, or sorry, not Tracy, Nicole said, how we can tell Peter has kids, they're cooked. Yeah, like the world is looking at Brian Walshe like he's cooked. This strategic move by the defense, I don't think is going to change what the jury is presented with as a whole. And substantially, I don't think it's going to change that.
I don't think, and really, it's not going to change the trial much. The prosecutors are still going to put on the same evidence. You said the motions in limine didn't really work real well. The same evidence is going to be coming in the prosecution, whether they pled guilty to this or not. Now, again, the theory about him having to testify. He's going to have to explain, and again, one of the explanations could be because of that federal charge that he has. Why didn't you just call the police if it was self-defense? Why didn't you just call? Why did you, dismember? Why did we find your DNA and your wife's DNA in the dumpster? He's going to have to explain why he did that, and the federal charge may come out as part of his explanation for why he did it. We really don't know, and I hope they deal with it in an opening statement. Otherwise, I don't think it's going to work real well.
And the prosecutors still have the burden to prove, why did he do this? Why did he lie to police? Why did he move the body? Like, that is all part of the highest crime charge. Nurse of interest, thank you for gifting 5 lawyer memberships. Yeah, like it is. Somebody said it sounds complicated. Parker said the legal jargon like we're talking about here is complicated, but to me, the prosecutors have a pretty good story to tell. Now, can they prove he actually ended her life? That might be more difficult. And frankly, without the body, that does make it a lot more difficult. We don't know if there's handprints around her neck or, a blunt force trauma to the head or other ways that you can kind of explain it. This opens up a little bit of a can of worms. If you're the prosecutors, because we said there would be kind of a minor change in strategy. What are you kind of thinking? How would you try to use the fact that he's admitted these facts? How would that change the way you're going to use the evidence you still want to get in and kind of your strategy in the case as a prosecutor?
I don't think it would change my case in chief much. I think it would do a lot more preparation on the fact that he's going to have to testify. Because normally, I got to tell you, before this, I wouldn't have bet anything on the fact that he was going to testify. There's just no reason for it. There's no upside to him testifying. Now, there is a reason for him to testify, to explain all this stuff. Because again, they have no body. Early on they had, all these question marks that had been taken care of by the defense pleading guilty on these 2 charges. So it's going to make their case in chief easier. But I think all of the same evidence, all of it is still going to come in. I think they're going to still do the same prosecution. And then you may have some rebuttal after his testimony that they may be able to use. But as far as the case in chief, prosecution puts in everything just like they did before.
Right. I just don't know if this is really going to change any of the judge's evidentiary decisions. It did not seem like it when I was watching the motion in limine. It didn't seem like, this would be the thing that changed her mind, really. Tracy said, can he point the finger at someone else, le mama? I think they would have to let the prosecution know about a third-party culprit, and they actually have to have evidence of that. But he can say, I woke up and she was dead and I don't know what happened. It could have been somebody else. That's different than saying it was my mom or her mom or whatever. I don't know which mama you mean, but I don't think he's going to point to a specific third party. I think it's going to be more self-defense or I woke up and she was dead and I freaked out like that. Those are the 2 options I see for him, which again, he would have to testify to explain.
From everything I've seen, it looks like they were the only 2 people in the house. There was somebody there apparently earlier on, but they had left.
They had like a party or something.
Yeah, they had left, but they were the only 2. So it'd be really tough. They can say, some burglar came in or something, but it's going to be really tough for him to show that there was a third party.
How would the Commonwealth prove Anna is dead without Walsh's plea?
You can prove it by circumstantial evidence, and they've got some really good circumstantial evidence. You can prove it by the start with the text message or the Google searches. How do you get rid of a body? How long does it take before it smells if it's dead? Questions like that, the Google searches. Number two, you look at the dumpster. They found DNA in the dumpster, both of his and her DNA. So how does her DNA get in the dumpster? And whatever is in the dumpster got incinerated. So you've got and then you've got his false statements about her taking an Uber, and there's no evidence of her ever taking an Uber. So you got his false statements, you got Google searches, you got the DNA in the dumpster. You've got pretty good circumstantial evidence that she's dead.
Yeah, I want to see how the evidence gets presented in this trial because we've heard a lot, but I want to see how it actually gets presented in this trial and how they deal with issues like that. Netwoman said, can the prosecutor, I would say, here's something I will say that changed my mind with this plea. I'm more interested in this trial now. Like before, I kind of thought it was just going to be like a slam dunk easy, but like, let's see, the lawyers are going to try some different things, think outside the box, some different strategy. And I always love watching good lawyering. So I think there's going to be a pretty good legal battle here. In this case, if Netwoman, I'll put you back up on the screen in 1 second, but if there's not a plea, I still think this increased the chances of them taking a plea deal before trial begins. Do you agree or disagree with that?
Well, it increased their chances. Their chances were zero before. So it certainly increases the chances.
Never zero.
Well,
It's never zero, but I think
they're trying the case. So it was a zero before trial.
I think there's more of a chance now that there is some kind of plea deal. Netwoman, can the prosecution bring up his house arrest / forgery during the trial? Motive of losing breadwinner, maybe. Well, let's answer that question first. It seems like the judge is not going to just let them bring up those federal charges, but she may let them bring up that he's out on probation or that he did have some issues to where he's not the breadwinner now without really getting into the fact that he's, federal convicted felon. But we'll see how it comes out and what becomes relevant.
Right. A lot of times judges will let you get the facts in and try to sanitize it so that it keeps out the prejudicial items of, the forgery, but the fact that, breadwinner, those kind of things that don't actually say he's been convicted of forgery.
And sometimes what we'll do is we'll work with the other side and tell the judge, here's what we'll stipulate to, judge. Circumstances happen where he's no longer the breadwinner and whatever. And the defense will agree to that too, because if they don't, and then they're like, no, make them prove it, judge. It's like, okay, here's how we'll prove it with the federal charges. So it's like sometimes you work together to find a pacified way to say something. Second part of the question is, does Papa T watch the trial on 2 times speed as well?
No. I do not. Now I have gotten up to 1.5.
That's good.
Yeah, but not 2. I can't do that.
Ashley asked, Papa T, what do you tell a client ahead of them or ahead of time, in a case like this when it really doesn't look good for him? We've had plenty of those.
And we're honest. We do tell them it doesn't look good. We do tell them, I'm not a fan of percentages, so I usually don't do percentages, but I will tell them it's highly likely that you're going to get convicted. Things don't look good. And I do it with a comparison of the evidence, and I actually show them why I believe if the prosecution puts this on. And vast majority of the cases, probably 90% of the cases, once I present the state's case to them and I ask them, if you were a juror, what would you do? The client says, I think you're right. I think I probably would convict the person with this evidence.
Right. Okay, I'm going to play the rest of the plea deal now, and I want everybody now after that discussion, we're going to answer a bunch of more questions at the end. So if you guys have questions.
Not a plea deal.
Plea hearing, whatever. We're going to watch the rest of the plea hearing now and listen to it with an ear of, if he takes the stand, he's going to have to admit to this in front of the jury or he'll be impeached, right? That's important for especially what they say about the body. Just imagine this and imagine thinking, yeah, this guy's, definitely not guilty, which is what the judge wants to prevent, the prejudice of the propensity to commit the M just because he committed these. But also, if it is evidence of that, then we have a problem and the prosecution can use it. So we're going to listen to the second part. If you guys have questions, put them in the chat. We're going to answer a bunch of them after. It's only about 5 minutes long.
Thank you, Your Honor. Willfully conveying a human body in violation of Mass General Laws, Chapter 272, Section 71. On or about and in between January 1st and January 8th, 2023, the defendant Brian Walsh willfully conveyed away the body of Anna Walsh or the remains thereof from the Walsh residence at 516 Chief Justice Cushing Highway in Cohasset by conveying and disposing of Anna Walsh's body without a license or lawful authority, or the remains thereof, into dumpsters and/or garbage receptacles in eastern Massachusetts. The defendant's actions were willful. Anna Walsh was not a stranger to the defendant. She was the defendant's wife and mother of his 3 young children. The defendant conducted internet searches into disposal of the body, researched locations of dumpsters, and then traveled to those locations. In disposing of the body of Anna Walsh, the defendant did not comply with the law.
Thank you. Sir, did you hear what the Commonwealth just alleged? It would prove the case went to trial with regard to indictment number 3.
Yes, Your Honor.
And did you do those things or joins others in doing those acts?
Yes, Your Honor.
Do you understand that by pleading guilty to today, you are admitting the facts described just now by ADA Connor?
Yes, Your Honor.
Mr. Walsh, did you in fact willfully remove or convey the body of Anna Walsh or her remains, not being lawfully authorized to do so?
Yes, Your Honor.
Do you now plead guilty to these indictments willingly and voluntarily?
Yes, Your Honor.
Has anyone threatened you or forced you in any way to plead guilty to these 2 indictments?
No, Your Honor.
Has anyone promised you anything in return for your plea of guilty to these 2 indictments other than the terms of the plea agreement that we discussed? Excuse me, there's no plea agreement. That's what happens when you keep reading from the book, and you shouldn't. Has anyone promised you anything in return for your plea of guilty to these 2 indictments?
No, Your Honor.
Have you had enough time to discuss your rights, your case, your defenses, and the possible consequences of your guilty plea with your attorney?
Yes, Your Honor.
And do you feel that Attorney Tipton and Attorney Porges have acted in your best interest, that he and she have fully, fairly, and adequately represented you in this case?
Yes.
Are you confused in any way by any of the questions I've asked you today?
No, Your Honor.
As I understand it then, sir, you're pleading guilty to these 2 indictments because you wish to plead guilty because you are guilty. Is that correct?
That is correct.
Counsel, do you know, defense counsel first, do you know of any reason why I should not accept your client's guilty plea?
You not.
Same question to the Commonwealth.
Your Honor, I'll be brief, but we had spoke, this is a non-negotiated plea with the Commonwealth, and we had some objections to it. But my concern was where the defendant equivocates on the factual basis that the Commonwealth read in, that is one reason you should not take it. And the second is this count 3 revolves around improper disposal of Ms. Walsh's remains. And the defendant, when asked his marriage status, said that he was married. And consequently, Your Honor, then that is not an accurate relaying of his current status to the court and could be invalidating the plea. So I believe he has to be asked that question again. And I believe that if he continues to say he's married, that he's negating facts of count 3.
All right.
So that's important because he's not agreeing to the factual basis. If he continues to say he's married, I'm going to skip ahead. They go to sidebar and then they kind of come back and we hear from Brian Walsh on this issue. But that is a good point, number one. Number two, he's saying maybe we object to even them quibbling about the, saying the word M in the plea deal, but it just kind of is what it is. You have any comment on that?
Nope.
Okay.
That's good.
All right. Let's listen to this last 1 minute here.
So, Mr. Walsh, earlier today, I asked you whether you were married, and you answered yes, you were married. Do you remember that?
Yes, Your Honor.
And is it correct that you were married to Anna Walsh for a period of time,
Yes, Your Honor.
and that under the law, death extinguishes marriage? It may not religiously or otherwise, spiritually, but under the law, when someone dies or when someone is dead, you can no longer be married to them. Do you understand that?
Yes.
Yes, Your Honor.
And so are you married today?
Your Honor, if I may, insofar as previous discussions, for purposes of a successful plea colloquy and meeting the elements of the crime, he is acquiescing to the fact that lawfully he is not married today.
All right. You heard what your lawyer just said? Agree with what your lawyer just said?
Yes, Your Honor, I agree.
All right. Anything else that we need to cover?
No, Your Honor.
All right. To the extent that
All right, so that was it. It's just like a good lawyer to be like, let me answer this for him, Judge. Let me explain his answer here for you, Judge, just to break it down. What did you think about the whole marriage part and making sure that they got that right? So he's actually agreeing to the factual basis of the plea.
Well, those little details are important. The prosecutor said, maybe that would be another appellate issue. So, let's eliminate as many appellate issues as possible. We're already going to have plenty. So let's get this little one out of the way. So, I give the prosecutor credit for recognizing it. I think that it was minutia, but I think it was important. And I think he handled it the right way. And I would say he's a competent man.
I think that I give the defense attorney credit too, because I think she did the right thing too, how she stood up and answered it.
Right.
Lucy, and this kind of goes along with it. Is it legal to falsely plead guilty just for strategy?
Legally, no. If a client pleads guilty, he's supposed to be guilty. There's another way for pleading, no contest, where you admit they could prove the facts of the case, but you're not admitting to your guilt. So if you can't plead guilty, you plead no contest. If you plead guilty, you have to say you're guilty. And that's why she asked, do you agree with these facts? Are they true? Yes, they are true. So that she knows he is actually pleading guilty to the facts that establish that this crime was committed.
And are you pleading guilty because you are in fact guilty? Yes. So it was just kind of a funny question, almost made me laugh. No, it's not okay to commit fraud on the court, which is what that would be if you're pleading guilty and lying under oath, right? So that's a problem. But the other thing is like pleading guilty just for strategy. You're still guilty now, and you're going to have to deal with the punishment and the sentence, even if it's just for strategy. So, it doesn't really, it's like you plead guilty the way he did, you're guilty now. Legally, you're guilty. There's not really anything you can do about it. Dave Reese said, I think the judge said the federal conviction can't come in. The conviction is probably not going to come in, but some of the surrounding circumstances and potential motives of why he would do something to Anna Walsh, I think is going to come in. We'll see. Right. Dave Reese said he wasn't the breadwinner. Okay. Differing definitions and what they're going to say the motive is. Again, we'll just wait to see how those facts come out. Julie said, and this kind of two questions in one, I'm late, but why would a person do the cover up if they didn't do the crime? The pleading makes no sense to me. Thanks for your broadcast. It's funny. My dad always calls it broadcast. Question, Peter, how can he say he moved her body, but didn't kill her? Make it make sense. So, what do you think? We kind of talked about some of the reasons the defense would do this, but how is it possible that somebody would, move the body or cover it up and not commit the crime?
Well, and not commit the crime. Well, first off,
right,
it is a body or it is remains. So there's no question there was a death. So you have a death, and so the person is dead. The person that you move is dead. So you moved a dead person. And then the question is going to be, how did that person become dead? And that's going to be the whole point of the trial, is the facts of the actual death and how that occurred and what facts surrounded that death. That's the whole trial now.
Thank you for gifting 10 Lawyer memberships. That's awesome. Thank you guys so much for everybody that's gifting the memberships. To me, another reason that you might do this, where you get rid of the body but you didn't commit the crime, is you freaked. You freaked out. You knew you were going to be the suspect. You knew you hired a private investigator through your mom to follow her. You knew it was all going to be mad. You knew she wanted to leave you. You knew you were going to be in that inner circle and it was over for you. So you were like, crap, maybe if I just get rid of the body, they won't be able to charge me. That's what he was Googling. How do I get rid of the body? So that's the other explanation, if you want to call it that. Will a jury buy that? I don't know. Would you guys buy that? But I think that's kind of what he's going to go with, is he freaked out and didn't know what to do. Yeah, but if you call the cops, Ashley, you're suspect number one. And you're the last one with her. And if she fell down the stairs or something, it's like, well, obviously it's going to look like I pushed her down the stairs or whatever it may be. So that's kind of the explanation and the argument. But if the defense, which I've seen defense attorneys try to do this in the past, they try to make that argument without calling their client, because they definitely don't want to call him to the stand if they don't have to. He's just a ticking time bomb if they put him on the stand. But the prosecutors better object to facts, not in evidence, for any theory of what happened to Anna Walsh if Brian Walsh does not take the stand. Now, one of the ways they can do it is while they're cross-examining other witnesses, they can say, well, somebody could Google those things if they freak out, right? Somebody could Google those things if they found a body in the morning, right? Somebody could Google those things. So when the cops are on the stand that did the Google searches, they can ask them hypothetical questions like that, maybe to try to get it in the juror's head that maybe there's this other theory, but it's not going to be clean and pointed unless Brian Walshe takes the stand, which creates other issues. And then in closing arguments, I would object to facts, not evidence, if they just ask those questions to plant the seeds, if nothing actually came into evidence that he did freak out because there was an accidental death in the morning.
Well, and the freak out too also could bring in the federal case. He's got a pending federal case. Oh, I don't want to go to prison. I'm out on, I think he was out on bond. I'm not really sure, but I don't want to go to prison. If they find out that that I killed her because she tried to stab me, I might go to prison. So I'm going to try to hide all this. And it may, again, the federal case may come in if he decides to use, something like that as a defense.
Yeah. Erica said the Robert Durst, he did that in Texas and it worked. Yeah, I remember that. That was a crazy one. Multiple crazy cases there. Ashley asked, when are opening statements? I believe they said December 1st, the substantive part of the trial is going to take place. So they already had 9. By the way, this was an interesting thought because we had a conversation about change of venue. They picked 9 jurors in the first day, which is crazy. They want to get 16. My guess is they're going to have a jury by the end of this week easily. Take next week off for Thanksgiving. The following Monday is when they're going to start. Were you surprised they were able to get 9 jurors in one day?
I guess it's hard for me to gauge what the level of publicity is up there on this case. But it shows that the judges, obviously it shows the judge was right. You can get a jury, and therefore we didn't need a change of venue, which is going to get rid of one of the appellate issues.
Mary said they have 12 now. So 12 in 2 days. It's 4 o'clock. So I guess it's almost the end of the day. So maybe they'll end today with 12, easily have 16 by the end of the week. So
easy.
Yeah. And she planned it out perfect. I think let all the jurors go home to their families for Thanksgiving. I don't know how long this trial is supposed to be. Probably a couple weeks, I assume. Although I heard somebody say it's supposed to be 100 witnesses, which is crazy. It won't be 100 witnesses. No. They always say that. They always, like, reporters always look at the witness list and they're like, there are 100 witnesses on the witness list. Like, it ain't going to be 100 witnesses. And then Lally's like, hold my beer. I've got plenty of witnesses for you in Karen Reed's first trial. With this plea, he'll still do a lot less time, though. Not necessarily if he gets convicted. Sometimes a plea deal, you get rid of one charge, you plead to the other 2. That's not what he did here. This was just an open plea. All right, people are saying 3 to 4 weeks or 4 to 5 weeks. So hopefully before Christmas.
If he gets convicted of M, that increases his sentence on count 2 to 20 years. Because, so that M conviction could also could really do that. So if it's manslaughter, I'm not so sure it bumps it up to that 20 years now.
Yeah, it'll be interesting to see if they go complete accident or if they try to go lesser included. I do think probably the best argument is she came at me or it was accidental. We were, struggling or something and I, pushed her accidentally and she fell down the stairs. To take some responsibility and say, convict me of this, convict me of manslaughter. I think a jury might be able to swallow that more than just like not guilty or self-defense or something like that. I don't see them coming back with a not guilty verdict. I think if I'm going to say the best chance for what a defense attorney would call a win, maybe not Brian Walshe, is convicted of a lesser included on top of these 2 crimes with some possibility of parole in the future. That's what I think.
I don't know the answer to this question. Maybe somebody out there does, but all the Google searches, were they after the death? Did he do any Google searches before January 1st?
Well, he did. There is some Google searches before January 1st. I think it's something about divorce law. Okay. There were Google searches. I'm trying to think of what they were. It wasn't like, how to end somebody's life. And that's another thing that the defense attorneys can do is say, listen, this guy admits what he does is wrong, even as horrible as it is. This guy Googles something before he does it. He never Googles anything about how to end somebody's life. Like if he's going to Google these kind of things, he would Google that too. And he didn't. He's obviously not, sneaky with his Google. So try to use his stupidity as like an advantage to you that this guy's so dumb. He Googles all this stuff, after the fact that's disgusting and gross. And now he's admitted to it. If he did the deed, he would have Googled about it. You would have found it somewhere. Like that's this guy's MO. Maybe. I don't know. We'll see, what a jury ends up saying. Miss Vicky said, have you guys heard the theory that Walshe is doing this due to being forced by the Ukrainian mob? Absolutely not. I have not heard that
I
theory.
missed that one.
Whatever. Who knows? What'd you say?
I missed that one.
Who knows? That could be as true as anything else. What do we know, right? What do we know? Other people in the chat are saying, yes, I've heard that too. Okay. Could be.
Can you imagine if imagine if he takes the stand and that's his testimony?
Oh my gosh. That would be hilarious. That would be absolutely hilarious. All right. I think that's all we got. You got anything else you want to mention before we go?
No, I think we covered it all. Yep.
Yeah. All right. Awesome. Thanks for coming on, everybody. Thanks for joining us. Hit that like button if you guys haven't hit it yet. And please make sure you subscribe, because as the jury is picked, if anything else pops up in this case, we will be doing a video. If nothing happens before December 1st, I'll be doing daily breakdowns. My dad will come on weekly for the podcast to give his takes. So we'll make sure that we continue to do that. Team Brittany, I always have the slope on my rangefinder unless I'm playing in the Internet Invitational. Next year, I'll turn it off. But all right, that's all we got. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.